Michael Popok, Legal AF. I want to do some reporting and analysis on Donald Trump's change tactics in his participation in various criminal and civil proceedings, because it has morphed, it has moved. I want to bring it to your attention and show you what I'm talking about and what we can expect into the future as more criminal cases happen. I think Donald Trump originally tried to ignore most of the trials that were against him. That would explain why in the E. Jean Carroll case, the defamation and sexual battery and rape case that was tried last summer, Donald Trump completely ignored the trial whatsoever. That was his first attempt at strategy. He wouldn't acknowledge it, except at press conferences and social media and at rallies, but he didn't attend the trial. He didn't hold press conferences near the trial, and he threatened to participate by way of testimony, but never did. And instead, we saw things like this when he went off to Scotland for some sort of ribbon cutting at a golf course instead of testifying about whether he raped and defamed E. Jean Carroll. Let's give an example of that clip.
Because of that, I have to leave Ireland and I have to leave Scotland, where I have great properties. I have to leave early. I don't have to, but I choose to.
Will you attend the trial, Mr. President?
I'll probably attend, and I think it's a disgrace. It's a disgrace that it's allowed to happen. It's called false accusations against a rich guy, or in my case, against a famous, rich, and political person that's leading the polls by 40 points. And I have to go back for a woman that made a false accusation about me, and I have a judge who's extremely hostile. And I'm going to go back and I'm going to confront this woman. This woman is a disgrace, and it shouldn't be allowed to happen in our country.
So that was what I'll call Trump 1.0. Ignore the trial, don't attend the trial, act like it's not happening, except take continued swipes and defame the person, the victim that you assaulted and raped, and then threaten to attend the trial, but don't actually attend it and run off out of the country to avoid hearing the music, as they say. That was Trump 1.0. We then saw Trump 2.0, where he said, well, I'm not getting enough press. I'm not getting enough oxygen. I'm not getting enough of the news cycle. I better do something else. And we saw that version in the New York Attorney General civil fraud case over 11 weeks that just concluded with closing arguments. And even in there, we have a 2.0 Trump and a 3.0 Trump. 2.0 Trump is, I will attend certain days of the trial, and I'll use that as an opportunity to go into the hallway to do, because the trial's not televised, to do spontaneous, spur of the moment, but not really press conferences, mainly with MAGA media asking him softball questions. Here's an example of that and the attack on the New York Attorney General and witnesses in the case.
This is just an attorney general that hates Donald Trump and wanted to run for governor, wanted to run for attorney general. And it's a shame. I think she should be criminally liable for this. She did this to Exxon, and they drove Exxon out of New York. Exxon paid billions of dollars in taxes. They're now living in Texas. Exxon is very happy in Texas. Other companies, because of what's happening here, are going to be moving out of New York also. This is an out-of-control attorney general. She's totally out of control. These loans were all good. The banks were extremely happy with me. They still are. We built a great company. We have a company that's very liquid, very strong, great assets. And she sued me because she wanted the publicity to run for office. They find nothing wrong. And I think if anybody was being fair about it, and I'm not sure you can even hear me because they don't allow microphones over here, which is sort of ridiculous. But if anybody's fair about it, you see, this is a case that should have never been brought, and I think we should be entitled.
Okay, that's Trump 2.0. Show up, attend as an attendee of a trial that you didn't have to attend at certain moments to confront certain people, and then do these ad hoc press conferences to gain the media advantage, the election campaigning advantage every day. But then at the end, in Trump 2.0, you refuse to ultimately testify in your case in chief. And so Donald Trump doesn't do that. But then we have an example of Trump 2.5, which is in the same case, the civil fraud case, brought against the New York Attorney General. He then had a new opportunity because there was a 1-month period, a reset, if you will, between the close of evidence after 11 weeks, the 40 witnesses, the thousands of exhibits that went on during the trial, a bench trial, no jury, not televised, of course, and the closing arguments. The judge gave everybody a month, said, we're going dark through the holidays, through January. I'll see you in the middle of January. And we just held that one. And then out of the blue, literally out of the blue, just the day before yesterday, Donald Trump's lawyers, in an email obviously written by Donald Trump, springs on the court that Donald Trump wants to do his own closing argument, at least part of his own closing argument. Completely unheard of, not allowed. When somebody's represented by counsel, the lawyers handle this aspect for good reason. You either represent yourself, we call that pro se, or you're represented by counsel and the lawyers do all the lawyer work. That's the way it works. You bought your ticket, sit in the stands. Let the professionals do their job. But Donald Trump being Donald Trump and realizing that he could win a news cycle while his leading candidates against him for the Republican nomination, Nikki Haley and the other guy, are getting some sort of press to try to figure out who's going to come in second in the I want to be Donald Trump's vice president sweepstakes. And so he wasn't getting enough press because he's not participating in those debates willingly. Intentionally. So he says, he just drops it into one line. It was like literally an email to the judge. I am going to give part of the closing argument. And the judge said, no, you're not. Unless you act like a lawyer. You stay on message. You stay on evidence. You stay on facts. You don't attack me, my staff. And if you do, I'm going to have you bound and gagged removed from the courthouse. I'm giving you a summary of the order, but that's basically it. But then on the day of, Donald Trump decided to act out and stand up and try to attack the judge. And it wasn't really a closing argument, but it was a minute and a half of attacks in the courtroom. That could be reported the next day, that day, on various headlines. Donald Trump allowed to participate. He wasn't really allowed. I mean, he stood up, participated. I wouldn't call it a closing argument. The closing argument was delivered by who I thought it would be delivered by. Chris Keiss, not Alina Habba, but Chris Keiss, who went in his own way methodically through the New York Attorney General's case and tried to dismantle it the best he could, although it's very hard given the overwhelming mountain of evidence against Donald Trump that was presented during the trial, as noted by the trial judge on a number of occasions. But, he kind of did his best there and tried not to attack the principal law clerk again in person and try to argue there's some political witch hunt going on, although they love to say that. And Donald Trump got to stand up and shake a tambourine and get the press excited because a shiny object showed up and they started reporting on it. But again, not televised. And then he could do a press conference. What else? So this is Trump 2.5. You show up, you try to elbow your way in, shove your way in like a bull in the china shop or a former president in the china shop and see what'll happen. And now we have a continuation of Trump 2.5. You show up for things now. Now he shows up instead of ignoring them and things by sitting there with his pout and his scowl, his Mussolini jaw, his long red tie, and his weird hair, that he'll, command some sort of attention or respect in the room. If that's what he was going for at the D.C. Court of Appeals level. Well, let me first show the clip of Donald Trump at the end of the New York Attorney General case after he did whatever he thought he was going to do and the little comments he made there.
I'd like to introduce President Trump.
Well, I want to thank you all, and we had a very momentous day in terms of what was learned and what they've conceded. They conceded two major points that were right in doing it. I don't think they had much of a choice, but they're very, very big, very powerful points. And I think we're doing very well. I think it's very unfair when a political opponent, is prosecuted by the DOJ, by Biden's DOJ. So they're losing in every poll. They're losing in almost every demographic. Numbers came out today that are really very mind-boggling if you happen to be Joe Biden. And I think they feel this is the way they're going to try and win. And that's not the way it goes. It'll be bedlam in the country. It's a very bad thing. It's a very bad precedent. As we said, it's the opening of a Pandora's box, and it's a very sad thing that's happened with this whole situation. When they talk about threat to democracy, that's your real threat to democracy. And I feel that as a president, you have to have immunity. Very simple. And if you don't, as an example, if this case were lost on immunity, and I did nothing wrong, absolutely nothing wrong, I'm working for the country, And I worked on very hard on voter fraud because we have to have free elections. We have to have strong borders. We have to have free elections. Those two things almost above all. And we found tremendous voter fraud. We have a list of it. We have some findings if you want it. The press doesn't like reporting it, but we found tremendous voter fraud.
Now back again, sorry for that. Back again, we've got Donald Trump who sits there scowling in the very austere August body of the 3-judge panel of the D.C. Court of Appeals led by Florence Pan, first Taiwanese American ever put on a federal bench. And she did a masterful job. It was almost like watching vivisection. She literally reached in, or figuratively reached in, to John Sauer, the lawyer for Donald Trump arguing the appeal, pulled out his heart and showed it to him during the oral argument. At least that's the way I interpreted it. She got right to it. Talk about a sniper. The sniper, she's a sniper in a good way, a legal sniper. She took him out within a minute of him standing up on the SEAL Team 6 question. About whether, are you saying that if Donald Trump ordered SEAL Team 6, as he's allowed to do as commander-in-chief, give orders to take out his political rival, that murder would be allowed and would be immune from prosecution? And everybody on this, watching this YouTube and watching this hot take is probably thinking, are they insane? Of course not. And that is the answer, of course not. Donald Trump's sitting there, very interesting arguments going on as they were being, as I said, completely dismantled and a live autopsy, performing a live autopsy, or the person alive while the autopsy was going on the audio recording that we have. And we'll just play the audio clip so you know what I'm talking about there, about SEAL Team 6.
I've asked you a series of hypotheticals about criminal actions that could be taken by a president and could be considered official acts. And I've asked you, would such a president be subject to criminal prosecution if he's not impeached or convicted?
Requirement.
And your answer, your yes or no answer is no.
I believe I said qualified yes if he's impeached or convicted first. We may be saying the same
question
thing.
was, okay, so he's not impeached or convicted. Let's put that aside. You're saying a president could sell pardons, could sell military secrets, could order SEAL Team 6 to assassinate a political rival.
Sale of military secrets strikes me as something that might not be held to be an official act. The sale of pardons is something that's come up historically and was not prosecuted.
But your brief says that communicating with an executive branch agency is an official act, and communicating with a foreign government is an official act. That's what presidents do.
They're very strong situation. There's very strong examples of potential official acts. If you look at what Chief Justice Mitchell said against Madison, he said, rising directly under Article 2, Section 1, that the courts, that the president's official acts are, quote, never examinable by the courts. And he says it like 4 different times on pages 164 to 166.
Donald Trump's sitting in the room for that. So that's kind of Trump 2.5-ish. Now we're going to Donald Trump 3.0. He's going to testify in another case involving E. Jean Carroll, which is coming up next week. Yes, there's a trial of Donald Trump next week. It's just not the one that you want yet. It's not any of the criminal cases. It's not even the conclusion of the New York Attorney General case. It is the E. Jean Carroll. I've been defamed a second time, or I was defamed when Donald Trump was president, for which he has no immunity. And I want my day in court. I'm going to get it for tens of millions of dollars in punitive damages, which I am quite confident a new federal jury in New York is going to award her. That trial starts next week. There have been a series of terrible decisions against Donald Trump because he's just wrong on the law and on the facts against his lawyers, Alina Habba and Michael Medallo. Donald Trump is listed as he is telling the world he's going to testify. Now, how many times, in fact, I'm going to put up a comment in E. Jean Carroll's lawyers where they say that in conversations with Medallo and Habba, they've declared that Donald Trump will testify. Now, what is the sports book betting line on Donald Trump actually testifying? How many times has he said he's going to testify and then he never does, or that he's going to do the closing argument and he stands up and sputters for a minute and sits back down? Or he says, I would have testified, New York Attorney General case in chief. I would testify, but there's no sense in testifying. E. Jean Carroll, I would come back and testify, but I'm busy in Scotland. Now he says it again. I'm going to testify. Criminal trials, I'm going to testify. He is never going to testify in any of those criminal trials against him. That I would pretty much assure you of. So What I've tried to do in this particular analytic hot take is to talk about Donald Trump's metamorphosis and his approach to this thing called the justice and court system and how he interacts with it, but always in a way in order to pivot and have a soundbite, a hot take, a media day, capture the news cycle, and then we move on. The circus moves out of town to the next spot on his itinerary. So we'll continue to follow. Will he or won't he? But from an analytic standpoint, does it matter that Donald Trump participates and sits in the audience during any of the hearings that involve him? And I think the answer to that, as a lawyer that practiced for a long time, is no. Judges like Judge Pan, the Supreme Court, don't care. They've had more famous people than Donald Trump in their courtrooms, and they get paid to be nonplussed by the appearance of quote unquote celebrity or celebrity apprentices or whatever Donald Trump pretends to be. So I'm not worried about that aspect of it. If he shows up during a judge bench trial like the one in Judge Engoron, where there's no jury present, again, I don't really care. Where we have to be careful is when Donald Trump comes in, unrestrained, unfiltered, unhinged, and unplugged in front of a jury, federal or state. Judges like Judge Merchan overseeing the Stormy Daniels trial, which will go to trial. When I say Stormy Daniels, I mean the hush money cover-up trial of Donald Trump for crimes related to Stormy Daniels, not that she's on trial. That trial, Judge Merchan in New York is going to have to be careful and protect the jury. Judge Kaplan is going to have to protect what's now going to be an anonymous jury again in New York next week against the E. Jean Carroll, in the E. Jean Carroll case related to punitive damages and Donald Trump already. That's been declared to be anonymous. The jury in Georgia will be anonymous pursuant to Scott McAfee's rulings there to protect them from Donald Trump. And then Donald Trump has criminal jury trials, as he's permitted to under the Sixth Amendment and under due process, in Florida and in the District of Columbia. So we're going to have to follow his taking this to Trump 4.0 and as it impacts juries. I'll continue to follow it one place. Don't touch that dial. It's the MeidasTouch Network and Legal AF. We do it every Wednesday and Saturday at 8 p.m. Eastern Time. And I'm the co-anchor on Wednesdays and Saturdays and one of the co-founders. If you like what I'm doing, give me a thumbs up. Leave a comment. Helps the network. Helps me stay on the air. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.